Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Hello, everyone. Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Hey, Bob, how are you?
I'm well. Good to see you, Sean.
For those of you who don't know, Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. My name's Sean O'Connor, and today's episode is titled Emergency Injunctions in Texas Business Litigation and How TROs and Temporary Injunctions Can Shape the Trajectory of a Commercial Case. Say that 3 times fast. Hey, Bob, I'm going to jump right in because this is a big topic. Let's start with this one. When we're in the conversation about commercial litigation in that context, what types of disputes most often lead a party to seek emergency injunctive relief in Texas courts?
Well, in Texas courts, in Texas state courts, I would say that most often it is an injunction seeking to stop a foreclosure. So, commercial property, loans in default, lender, and we've got non-judicial foreclosure in Texas, which means you post a notice down at the courthouse, you record the notice in the real property records, you serve the notice on the borrower, and you get to sell the property at foreclosure on the first Tuesday of the month, provided you've given the appropriate statutory notice. So, that's a very easy process to complete. And so often right around the first of the month or the last couple of days of the previous month, you see lots of injunctive cases getting filed to stop foreclosures. Another common type of case involves former employees who have covenants not to compete, and they've violated them. They've gone to work for a competitor, or either companies, or former employees, or companies that had previously been working together with the plaintiff, but are now competing with them and are using their confidential information or trade secrets. So you seek an injunction to try and stop that.
Well, that may be related to this next question, thinking about, when a company believes immediate harm is imminent, how does the process for obtaining a temporary restraining order typically unfold in Texas state or federal court?
Well, in state court, there is a difference between state and federal. In state court, you file your petition, which is the instrument that initiates a lawsuit. You have to you combine it with an application for injunctive relief, which has to be supported by an affidavit or affidavits. You get it on file, and then you have to give the opposing party, or if they're represented by counsel, their counsel, at least 2 hours notice of when you're going to present it to the judge and to ask for a TRO. And then you get a hold of usually the court coordinator about when you can present it to the trial judge. You go down to the courthouse, and then if the other side is able to get their lawyer down to the courthouse at the same time, you have the argument right there.
Oh, wow.
And so, and it started during COVID and continues to some extent is doing these hearings by Zoom. In federal court, it's rare to get the process moving that quickly. You generally file a complaint, you seek a TRO, you've got to get it scheduled. At least the judges in the Northern District of Texas and some of the judges in the Eastern District are not going to grant ex parte TROs. In other words, they want the other side to have an opportunity to be there and be heard. But they're not evidentiary. You go off the papers that you've submitted, including the affidavits, and argue the case to the judge.
From a strategic standpoint, how does the decision to pursue emergency relief affect the overall posture of a case, in its earliest stages?
How strongly do you feel that you can get injunctive relief?
Mm-hmm.
Now, in the foreclosure context, that's really the ball game there, is to try and stop the foreclosure. So you're obviously going to go for it.
Mm-hmm.
And if you don't get the injunction and the foreclosure goes ahead, then you've the lawsuit's pretty much over at that point. In the employment, the former employee case, or the competitor who's gotten or is misusing or is using your confidential information, that's a little bit more of a strategic consideration. You may need to get some discovery before you go in for injunctive relief, because while it's not case dispositive, the decision on the injunction really tilts the field strongly in favor of whoever it is that's prevailed. You can get, even if you can't get injunctive relief, you can still pursue the case from a damages perspective. But, like, for example, the covenants not to compete, you've got a competitor who's hired one of your former people. If you get an injunction that prevents that employee from working for that employer, that pretty much ends the threat. Most employees or former employees don't have the financial resources to fight a case like that unless their new employer is going to stand behind them and pay for their lawyers. A lot of times the competitor, the new employer, gets brought into the lawsuit on a tortious interference with contract theory. Sometimes there's a divergence of interest between the employee and the new employer. Maybe they weren't fully informed about what the situation was. So that can be very strategic in terms of, do we go in? I've got a case right now where we opted not to go in for injunctive relief, and instead get our discovery done and look for damages.
I feel like you touched on this a minute ago, but just to be clear, what evidentiary showing does a court expect before granting a temporary restraining order or temporary injunction in a business dispute?
Well, so the temporary restraining order is done on the papers. So there's there's a petition. There's usually an affidavit or affidavits setting forth, that I've got a probability of success on my claim. Plus, here's the irreparable harm I'm going to face. Like, the loss of, in the foreclosure context, that's pretty much a given, because the loss of a piece of property is considered to be unique. And so if you lose ownership of it, then that's irreparable, usually. So, you don't really need to you need to hit all the right points, but it doesn't have to be really extensive. Now, when you get to the temporary injunction stage, or in federal court, it's a preliminary injunction, that is an evidentiary hearing. And, the judges, in my experience, they, particularly on the element of irreparable harm, they want some evidence that they can hang their hat on, and because they've got to articulate in the injunction what the irreparable harm is.
Right.
So, they need that. And injunctions that fail, usually it's because of the irreparable harm element.
So once a temporary injunction hearing is set, how does the preparation for that hearing differ from, say, that of a traditional trial?
Well, it's a compressed time frame. A lot of times when you file, you also file a motion for expedited discovery, so that you can start discovery sooner than you otherwise would. You can, get documents or get interrogatories answered on a faster time frame than you normally would. You get depositions within a compressed time frame, and so it's a compressed time frame. And sometimes, like if you've gotten the TRO, it's not all that uncommon. The other side now wants their own opportunity to conduct discovery, that they'll agree to extend it so that you both have an opportunity to get your discovery done. before you have the temporary injunction hearing, because the temporary injunction hearing is it's like a bench trial. You call live witnesses and present documentary evidence, and the other side gets to cross-examine, and the judge may have his or her own questions for the witnesses.
Right. So, I mean, when you think about your own experience, how often does the outcome of an injunction hearing effectively determine the direction or resolution of the broader litigation?
Well, so in the foreclosure context, it's pretty much ball game. If the foreclosure gets to go ahead, then
Game over.
Yeah, game over. If you get the injunction, then it's not necessarily case dispositive. You do have some leverage there. The other side's got to figure, well, if you got past the TRO stage, you've got at least a healthy shot at getting a temporary injunction in place, in which case there's not going to be a foreclosure. There's not going to be, whatever it was that you were doing that you're now prevented from doing until trial, which, could be 18 months, 24 months, sometimes longer. So,
Wow.
That will really color the course of the litigation from that point forward, and should provide some impetus towards getting the case settled.
Interesting. So if you're a company, let me ask, if you're a company defending against an emergency injunction, what strategic considerations become most important in responding quickly and effectively in that scenario?
Getting your lawyer up to speed pretty quickly, and understanding. Sometimes it's days, but you need to get them the information that they need, so they understand the situation and they can press your strongest points with the court, whether it be on the lack of irreparable harm element, for example, in the non-compete arena, there are judges who are not really disposed to enjoin somebody from working for somebody else, unless there's some real threat that there's going to be the misuse of confidential information.
Yeah, it seems like the non-compete thing nationally has been in the news quite a bit in terms of the lack of enforceability, or things move in trends, right? It seems like it's generally shifting against that.
Well, so for example, under the prior administration in Washington, there were both people at the FTC and the National Labor Relations Board, political appointees, who issued guidances or memorandum basically indicating that almost all covenants not to compete were unenforceable or were illegal labor practices. And that I had a case where that became an issue, that the employees went and filed complaints with the NLRB. The NLRB started an investigation that really colored the whole litigation. Now that there's a new administration, there are people with a different view of covenants not to compete they're more favorably disposed towards them. Those guidances have been withdrawn, it's at least you don't have that sort of administrative impact or potential effect at this point. So, yeah, I mean, it kind of comes and goes with the seasons and with who's got the political power at the moment.
Interesting. Yeah. Well, politics aside, I'm thinking about a scenario where corporate decision makers are weighing whether or not to pursue, or to oppose emergency relief. From your seat, what factors should shape that evaluation beyond the immediate urgency of that dispute? Are there things that decision makers should be paying particular attention to?
Well, I mean, from the plaintiff's point of view. It's, what is the scope and the magnitude and the seriousness of the harm that you're facing if you don't get the injunction. From the defense side, it's, just to give you an example, sometimes they're seeking injunctive relief that, say they're seeking injunctive relief to prevent you from using their confidential information, and your response is, I don't have any of your confidential information, and I'm certainly not going to use it. Then you might consent to an injunction that prevents you from doing something that you're not doing anyway. I mean, the findings that the court makes to support injunctive relief are not binding in terms of the future course of the litigation, and they're not disclosed to a jury that's going to later decide the case. The fact that there's an injunction and the judge made these findings, that doesn't get to the jury. So, I mean, if it's from a defense perspective, if it's no skin off your nose, you may want to avoid the expense of gearing up and spending a couple $100,000 to fight an injunction that you really don't care about.
That's going to do it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. Thanks for being here, Bob.
Well, thank you. Good to see you again, Sean.
To learn more about Robert and his firm's work in business and intellectual property litigation, visit the website carterarnett.com. That's Arnett with 2 T's. Thanks for listening. I'm Sean O'Connor. And remember to like, leave a review, or subscribe to the show so you don't miss the next episode. Have a great day.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.